Good afternoon, everybody. I'm Denny Major. I presented before, but it's been a while. I've been with Haynsworth for about 18 years now, getting close to 20 years. And today we're going to talk about a topic that I'm fairly passionate about, which is addressing the risks and exposures of hiring key employees from competitors. It's a pretty common fact pattern that I see because I handle a lot of these cases, both on the plaintiff and the defendant side. But for many small and medium-sized companies, and even some of the bigger companies, it's unlikely that they're going to experience that more than once. And in these kinds of cases, and the risks that are inherent in hiring a key employee can catch them by surprise. In my experience, I've probably handled about the same amount of cases on the plaintiff side versus the defendant side. And the plaintiff, obviously, in this scenario, would be a former employer of an employee, of a key employee. The defendant would be almost always that employee is going to be a defendant. And then most of the time, the hiring employer is also a defendant. And so I've been about equal plaintiff and defendant on each side. I've done a presentation before for Haynsworth on the plaintiff side and really about protecting information and non-competes. This side to me is really even more important than the other side in many ways because it's where there can be such significant exposure. On the plaintiff side, an employer has control. The one that's the former employer, and if things just are not going well, you can cut the case loose. But on the defense side, sometimes in a bad case, you're just held hostage, and one or two stupid things that an employee has done can ultimately cost the company millions of dollars. And so, I've had so many cases on the defense side where I feel like I'm telling the employer, I wish I had a time machine. I could help you so much and save so much money. But unfortunately, I don't. And so, maybe if I give presentations like these more often, maybe it'll at least put somebody on sufficient notice to have this be on a company's radar to be a little bit more proactive and prevent some of the problems that we see on the back end. All right, this is the next slide. Haynsworth, as I mentioned, I've been here for 18 years. We're a full service firm. We've got 115 attorneys. We've got in 5 different cities. Go ahead and ask questions as you have them in the chat, and I'll try to keep my eye over at the chat box and address them while we're going through this presentation. And bear in mind that we will send the presentation with the slides after the presentation. So here, this is sort of an overview slide of what we're going to cover today. The first point that I want to make sure that I make you understand is the potential exposure that comes with hiring a key employee. And what we're going to look at there is some of the verdicts that have come out. Not just there's a case study or a study that sort of analyzes verdicts in these kinds of cases in a macro sense that we'll discuss, and we're also going to discuss some very particular cases that I think are interesting. The restrictive covenants piece of this is important. It is absolutely, in most of the time, a big part in these cases. But I feel like that's sort of a known evil for the most part, not always. In the cases that just deal with restrictive covenants are far less expensive and problematic to litigate. Information transfer is an absolute monster, and it's a hidden monster in many cases. On the defense side, usually by the time I get involved in these cases, most of the damage has already been done. And if there's a bad document, which there often is, my role, I feel like, is largely damage control. And I'm honestly, a lot of what I'm doing is trying to convince my client how screwed they are. And that's difficult to do. But the reality is we're going to see juries hate when employees take documents. They will punish a company that hires an employee that's done that. They will punish that employee And there's reasons for this that are more theoretical on my part than others, than scientific, I should say. But and I won't go into all of this, but the plaintiff in these kinds of cases has a lot of advantages at trial and how they can present the case that really puts the defendant at a disadvantage. And it does not matter how good the defendant lawyer is. I mean, I've been involved in one of these trials before, a long 3-week federal court trial. I was sort of tangentially involved in one that occurred about a year ago. I think those are the only two that have occurred in the last 20 years. And I think in both cases, the defendant's lawyers did a great job, but it just is difficult to overcome the challenges that they have. And I'll say on the plaintiff's side, when there's a smoking gun document, it is so much fun. I love those cases. Conversely, when I've got defendants where there's a smoking gun, it is miserable. These cases are really nasty. They're like family law cases anyway, because you've got an employee who's upset. He probably left for some reason that at least he thinks is legitimate. And, the former employer has hurt feelings, and it just is nasty to begin with. And bad documents make it a million times worse. By the way, I'm gonna warn you, I probably will use the pronoun he often in this presentation. And frankly, I hope I don't offend anybody with that. Every case I've ever had was a male employee taking documents. There was one where there was a female employee involved, but she was really just under the male employee. So I just, when I'm thinking about these cases, I'm thinking about all the cases I've had, and I just tend to use that pronoun. I hopefully won't offend anybody with that. But going back to what I was saying, the best value that I have provided as an attorney is the very few times, and it's really just a handful of times, when a company has come to me before they hired the employee. Usually the reason that they come to me is to talk about, a non-compete or non-solicitation covenant that the employee is subject to. And that's important. Sometimes employers don't even recognize that issue, but that is an important piece of the puzzle for them to come to me for that. But it usually has not occurred to them to worry about all of the other problems and really worrying about information transfer that can be far more dangerous. But once they come to me, that's something we discuss, and we go through, strategies to help mitigate the risk of that. Usually there's a component of interviewing and discussing the issues with the employee to make sure that he understands the issues that can occur if he takes documents. I feel like in those cases, I mean, there's no scientific number I have, but I feel like the return on investment for the amount of money I bill versus the amount of money I save is far superior to any other hours I spend as a lawyer, to be honest with you. I'm so tired of telling clients who come to me after the fact that I could have saved them millions of dollars if they had come to me earlier. I feel good about the handful of cases where I get to do it on the front end. Let's see. Let's go to the next slide, actually. Well, actually, let me go back to this. One thing I want to mention is I mean, I'm on both sides of these cases. I don't really sit around and judge too much what employees are thinking when they take documents with them. I will say, so often, I don't think these documents make a difference. I don't think it helps them. I think that probably they're stressed out about the change. I don't think they're thinking very rationally, and they do it, and almost always they will tell me, if I'm representing them, like, I don't know what I was thinking. I don't even need this stuff. And conversely, when I'm representing plaintiffs, you'd be surprised. I'll go, and usually the plaintiff, on the other hand, is just so upset about documents being taken, and they can't believe it, and it's the worst thing that's ever happened. And I'm kind of like, okay, well, let's sit down, let's look at these documents that he took. How are we going to show that really helped them? And it's kind of hard for them to articulate. I'm like, I mean, usually you can do it, but it's very vague. It's kind of general. That's one of the things that I think helps the plaintiff, is with a jury, you can sort of stay up at the 30,000-foot level. This is so valuable. And, when you're the defendant, you're trying to poke holes into little things, and you're getting into the weeds that the jury doesn't understand. So, the juries wind up most of the time siding with the plaintiff. All right, so just real quick, this is pretty boring, this part, but these are the typical claims that we see in these cases. There are others that come in, but these 5 are in just about every one of these kinds of cases. I'm not going to read them. I will say that employers are often, but not always, named in the initial suit. Usually the employee, well, always the employee who left and went to the new employer is named. Many times the employer that hires that employee is named initially, and then other times, if they're not named initially, they will be added later if there becomes evidence that's revealed during discovery that gives you a better avenue to sue the hiring employer. I will say too, even where the employer is not named as a defendant, they're usually on the hook in some form or another. I mean, they've invested in this employee and hiring him. And many times there's been an express indemnity agreement ahead of time to at least cover, defense costs. Even when there hasn't been an express one, a lot of times the employer doesn't want to hang the employee with, who they've invested in out to dry. The other thing is if the employer doesn't kind of help the employee out and it starts going south, that employee may throw the employer under the bus. And that actually happens. I've had two cases where that has happened, where an employer, in one case, the employee actually left and went to another company. That doesn't get rid of the lawsuit, but the employer stopped paying for the employee's fees. And that employee went and ran to the plaintiff and was like, hey, how can I help you out? I mean, there was an affidavit from that employee the next day, talking about how bad the employer was and how the employer helped him take documents and all that. So there's a practical reason in the litigation for, not wanting to hang the employee out to dry. Anyway, this presentation is from the perspective more of the hiring employer, but even when the hiring employer is not initially a defendant, they're going to have to be very involved in this case usually. So I do this. I'm not going to dwell much on non-competes because that's a whole other presentation. But I mean, I do want to keep in mind that well, so often hiring employers, if they come to me after the fact, sometimes, like I said, they'll come beforehand and want me to look at the agreement, which is great. A lot of times they don't. And the thing that I get from those employers when I say, I mean, what did y'all do to figure out whether this was valid or, how you're going to avoid him violating it if it is valid or if it could be valid. And they'll say, well, I thought non-competes were invalid. And I mean, that I know now there's the FTC rule that might have confused people and it's not, it's been struck down anyway, but I mean, even before the news about the FTC rule, I used to get that. I thought they were invalid in South Carolina. And they're not completely wrong. I mean, there certainly are holes that you can poke in non-competes, and some of them are, terrible and probably invalid, but a lot of them, it's not going to be real clear. And a court will enforce restrictive covenants that are narrowly tailored and especially non-solicitation. So there's absolutely reasons to be worried about the non-compete and non-solicitation agreements. Don't overlook them. Don't just assume they're invalid. But the real thing I want to touch on here is information transfer, and I'm using that term. That's really my term for this presentation, but it's just describing an employee taking information. If it's information that's not confidential, then it's not, there's nothing wrong with that theoretically. Sometimes there's return of document provisions, but as a practical matter, I don't really want anybody making that distinction because what people think is confidential versus what a court may say is confidential are two very different things. And there's just not a scenario where you want an employee that you're hiring to be taking documents with them, whether you think they're confidential or not. I do want to take this opportunity to note too that taking documents is not really the standard that we're looking at under the law. The law doesn't distinguish between written documents and using confidential information or trade secrets that are in the employee's head. It's just as illegal for the employee to be using trade secrets or confidential information just by virtue of having memorized it as it is for them to use it from documents that have been taken. But as a practical matter, in most cases, it's going to be very difficult to prove that that employee is taking or is using trade secrets or confidential information without showing that the person took documents. There are some cases where that happens, and I'll tell you the way that usually comes out is that there's some emails or internal correspondence with the employee or even maybe about the employee that says something like, hey, well, back when I was at ABC Corp, we used to charge this, and I'm sure they offer this product, so they're charging X, and those are the kinds of things that might get you in trouble without showing that actual documents were taken. For the most part, as we're going to see in a little bit, the whole thing gets kicked off with some evidence that documents were taken, and it's really the taking of the documents that I think juries have such a hard time overcoming. So that's more of what we'll be talking about today. But I do want to make clear that just because there aren't documents taken, it doesn't mean that the employee can go and use something that's confidential or trade secret. And the important point of this, maybe above all else, and I've already touched on this, but dealing with a case with non-competes and non-solicitations, that's one thing. And it can be expensive, it can be stressful. But if you add evidence that the employee took documents, that saying that that's gasoline on fire is a tremendous understatement. It taints the entire litigation. The scope of discovery is so much broader. It is I would take 100 cases dealing with just non-competes and non-solicitations versus one that deals with trade secrets. It just is a totally different litigation process. So I wanted to point this study out. This is a 2016 study. I looked quickly to try to find something more recent, and I saw a couple of studies that indicated that maybe the number you can see here that it says 85% of employees admitted to taking company documents that they had created. The more recent studies that I saw indicated maybe 50%, but they weren't, the methodology behind those studies was suspect and not very big statistically. So I don't know how much I would put stock in that. I think the BISCOM study was a little bit more comprehensive. 50% is still high. And, I know there's this distinction here between information they created, but that's in the scope of their employment. So that document, it doesn't matter who creates the document. If it's created in the scope of that employee's employment, the employer still owns that document. They own whatever intellectual property is contained in that document, whether it's a copyright or a trade secret or confidential information. It makes no difference whether, John Smith created it or whether his, colleague Jane Doe created it. That employer owns it. You don't get to just take documents you created just because you created them. So it's a little scary that there was that many people that said they didn't feel that that was wrong. And then, 30% admitting to taking company documents they had not personally created is pretty high too. One question that I was interested in from this is, if so many employees admit to taking documents, why do juries hate it so much? And I've wondered that before. I don't know the answer. I mean, I've got a couple of theories. I mean, one thing I'd point out is these are mostly white. I mean, if we're talking about employees taking documents, we're talking about white collar employees, and that's not necessarily all of what's going to be reflected on a jury. And then I think also and this is true in any trial. I mean, we're looking at everything in hindsight, and we're sitting there in a courtroom, and the candor of trial and the process of being in that courtroom just puts a very different perspective on everything. And I think that when you've got evidence of an employee doing something like taking documents, it just looks a lot different sitting in that courtroom than it does to that employee while they're sitting there uploading the documents or printing them or whatever it is. And so, this statistic is important because that's the people we're hiring here. There's a good chance that they have documents they have taken. All right, so the name of this slide is, but Denny, there are no trade secrets in our industry. I would say, I mean, if you ask me if that has been said to me in every case where I've represented a defendant, I would say, if I guessed, probably no, but it may be every case. I mean, it happens, I feel like every time, and it doesn't matter what industry they're in or exactly what the employee's job description or title was. Everybody says there's no trade secrets in our industry. Everyone knows what everyone else is doing. And I totally get where that idea is coming from, and I want it to be true so often. Sometimes maybe it's what should be true, but the reality of what the law is and the process of the law just obliterates it. And it is such a hurdle for me to overcome representing clients who keep telling me this. And I'm having to show them that's just not how this is going to work. I just want to upload my experience to that client so that I don't have to spend so much time trying to convince them that it's not that simple. So, the first problem with that idea is that in lay terms, a trade secret is so much broader than what people think. I mean, so much broader than what lay people will think. And I'm going to give you just a very simple definition. This gets you 90% of the way there, but trade secret can be any information that's not readily known, that's confidential, that has value, doesn't have to have much value, and it is the subject of reasonable protection efforts. Those things are factual issues that a judge most of the time is going to let the jury decide, unless I can show that, oh, that's available on the internet. You're probably going to have a jury making that decision as to whether it's a trade secret or not. And the real, like, a demon that's in these cases is that a compilation of public information can be a trade secret. That proposition gets absolutely abused. So, I mean, it makes sense in theory. Let's, like, what everybody thinks of with trade secrets? You're probably thinking it right now. The Coca-Cola formula. I don't know if y'all been to the Coca-Cola factory. I took my kids there in June, and they've got that big, like, safe or whatever where the Coca-Cola formula is supposed to be, and like nobody really knows it. They only know pieces of it or whatever. Well, if you think about it, the Coca-Cola formula is almost certainly a compilation of publicly known items, right? The distinction there, though, is that the compilation and the amounts is greater than the sum of its parts, right? But that's not exactly what the law says. There's some theorists that are kind of trying to advocate for that, but that's not exactly what it says. And the practical reality is that we're dealing with like judges who they're over there sentencing some guy to 10 years in prison for felony DUI or whatever. I mean, they're worried about criminal stuff. They're worried about like property issues. This is like a very tiny. I mean, a lot of judges, when they're facing a trade secret issue, it may be the first and only time they ever face it. They don't have time to understand it. They don't probably fully understand it, and they hear all this stuff about compilations. What happens is, and I do this when I'm the plaintiff, right? But the trade secret plaintiffs will bundle together a compilation of public information and they'll call it a trade secret. So, if you find out somebody took 20 documents, they're going to call that a compilation or some minor, some subset of compilation. And as a defendant, you're swinging at a ghost because the minute you say, oh, well, ABC Corp, let's say the compilation is the preferences that ABC Corp has for the newsletters that you're creating for it. Well, okay, ABC Corp's got 12-point font they want. And okay, well, yeah, but we know that from looking at the newsletter. That's not a trade secret. Yeah, no. It's not just that. It's the compilation of that with what colors they want. And then you've also got DEF Corp's thing. So it's the compilation of all those things. And you're swinging at a ghost when you're trying to defend that compilation trade secret thing. And judges never hold plaintiffs to the standard that they should as to identifying these trade secrets. And, the plaintiffs' lawyers who do that, they're doing probably what they should do. It's what I do when I'm representing plaintiffs. You don't want to have to identify exactly what it is. It's so much harder to defend it. The practical reality is that it makes these cases very difficult to defend. I've fought and fought and fought so many times on that issue. I've got at least one case right now where I'm representing the defendant making that argument, and I've watched other lawyers fight this issue, and it's just very difficult to win on it. And maybe the only people in the world that understand what a trade secret is less than a judge is a jury. I mean, the jury didn't know which way is up to begin with, so they're not going to understand all this trade secret stuff. You're going to have the plaintiff over here way high up talking about how valuable stuff is. The defendant's down, oh, well, yeah, ABC Corp's font's already, it just gets lost on them, and they hear the higher level stuff is what they remember. So it's a huge burden to overcome in these cases. And then a huge problem too is if documents are taken, this goes back to what I was saying earlier about those cases where documents are taken and there's evidence of it, which, there's usually direct evidence of that if there's any, is, the plaintiff's going to say if it isn't confidential or it isn't valuable, why did you take it? That's an easy understand, that's an easy argument to understand from the jury's standpoint, and it's juxtaposed against a defendant trying to get into nuances in the industry. And so, under those circumstances, more often than not, something gets found to be a trade secret. And I also would note, I talk about confidential information, too, that something doesn't necessarily have to rise to the level of a trade secret to be protected. There can be liability under fiduciary duty standards and non-disclosure covenants for using or disclosing confidential information. Okay, so this is an important slide. This talks about some of the verdict statistics. This is from I guess a report that Stout did. In fact, Stout's an expert in one of the cases I have on the other side. They do a lot of testimony and stuff in this area. This is probably a little bit of an advertising piece of a study, but it looked pretty well done, in my opinion. And it shows they studied for 5 years between 2017 and 22, almost 10,000 cases involving misappropriation of trade secrets. 81% resulted in judgments favorable to the plaintiff. I don't know exactly how many of that 9,600 would have included that, but maybe all. But I mean, a lot of times you're probably just going to see like a stipulation to dismissal, and there'll be a settlement that you wouldn't really know, what the nature of the settlement was. But I bet they're probably counting like preliminary injunctions in favor of the plaintiff and things like that. There, 84% of the trial verdicts that they saw were in favor of the plaintiff. That's pretty big, right? I mean, there were only 271. I say only, that's a pretty decent many, but 84% in favor of the plaintiff. And then they studied 54 federal court cases that had a verdict. They only studied cases where there was a specific allocation for trade secrets. So a lot of times you'll have multiple causes of action, and the verdict form will just kind of be like, do you find for the plaintiff or the defendant, and then how much? They don't really always allocate amongst causes of action. But in federal court, they do more often than in other cases. So they only looked at those. That's why this is a smaller sample. And interestingly, the aggregate total damages, like for all the causes of action, was 2.5 billion, which comes out to an average of $46 million per case in those cases. And then 18 million of that was allocated specifically to trade secrets. That $46 million is closer to the real number, though, because of the way that things are going to work on that verdict form. They're probably the damages, they may just be allocating part to that because that's the way they did it. But that $46 million is really what I would be more worried about. Now, the median award was far lower, which indicates it was pretty top heavy. But that's just for the trade secrets allocation. So that median would still be, it would be way higher if you included like all of the damages awarded by the juries in those cases, including for other causes of action. And also that doesn't even include punitive damages or attorney's fees. And under the Trade Secrets Act, you can potentially have to pay the plaintiff's attorney's fees if the plaintiff wins. So that $1.3 million number, to me, that's not nothing. And it's probably in reality substantially higher. A couple of recent cases I wanted to note, and we'll focus more on that first one. It is Prismian versus Sterlite, which it was a case. I don't know if you all are familiar with it, but it's been going on in the Midlands. So Prismian's a big manufacturer in Lexington County, and a competitor out of that's really based in India, called Sterlite, opened a plant in Kershaw County. Sterlite hired a former key employee of Prismian, and said that employee took documents. Now that former employee also had a non-solicitation clause. That non-solicitation clause, that whole agreement got thrown out. The jury didn't even know about it. It's kind of important because everybody, when they do come to me, they're worried about the restrictive covenant. But telling you, the demon is if you take documents. Nobody thinks about that until it's too late. In that case, the jury awarded $96 million, 96.5 million, even though it never lost a sale. So Prismian, it manufactured cable. It sold every damn last bit of cable product that it could make. So it really had no actual loss viewed from that perspective, but it got a $96.5 million judgment based on, they used a reasonable royalty measure of damages. I don't want to get into that kind of detail at this point, but it illustrates the flexibility of trade secrets remedies, and that's another reason why these cases are so dangerous. And I happen to be just tangentially involved in this Prismian case, in kind of from an outside perspective, but I was monitoring it, and I watched a little bit of the trial. And the defense attorneys, I thought, did an excellent job in that case. I mean, they got some rulings that were in their favor, and still this was the verdict in this case, which is, it's pretty scary, if you ask me. Another thing I'll point out, I had tried one of these cases before, and just having been really experienced in them, I remember sitting there. I kind of had to deal with trial prep with them for one piece of it, and asked them about their jury. And they said, well, we were worried about it at first, but we think we're okay. I was like, and then they told me kind of like the employment backgrounds of the jury, and I was like, oh man, I mean, I didn't want to tell them because they have to be positive. They're in trial mode. But I was like, man, I mean, it's such a scary thing to think about these people that don't know anything about the business, trying to make a decision, for almost $100 million relating to your client. And that's the situation you find yourselves in if you have an employee that is key and takes documents with them. Another case here, I included, this got overturned on appeal. Oh, and by the way, Prismian, I think it's either in post-trial motion still or on appeal, or I don't know, maybe they settled it by now, I don't know. But I shouldn't mention that because I guess it's possible that could get overturned. But I don't know enough about their issues to say one way or the other on that. But this case, there was a $2 billion award out of Virginia. It got overturned on appeal. But again, I mean, that's pretty, $2 billion in a trade secrets case. In Virginia Circuit Court, that shows you what juries are capable of in these cases. And that, by the way, that number wasn't even included in that study that the Stout did that we looked at on the last slide. That was not one of the top heavy verdicts. So even if you win, even if you are to win, it's not going to feel like a win, because the discovery that you're going to pay for, both in terms of attorney's fees that you pay your attorney, and the time that your employees are spending worrying about it is absolutely huge. So the first thing that you have to worry about if you get all of a sudden a summons and complaint that deals with this stuff, and if you engage me, like, there's a million things I'm worried about. First of all, you're dealing with a preliminary injunction off the bat, and you got to race to worry about that. But also, you've got an evidence preservation problem immediately, because we're talking about digital evidence that is getting overwritten every second. And you're trying to figure out what digital evidence may be relevant, what custodians may be relevant. You have to get forensic computer people involved almost immediately to make sure that they properly forensically image the computers that are at issue, the phones of the people, the key people at issue, any tablets, things like that. All making sure that the right procedures and holds are in place for all the email and all the network stuff. And we're not just talking about making sure the documents are still there. We're talking about the metadata about those documents. I mean, all that metadata can be critical in these cases as to when a document was opened, when it was saved. All of that is important, and it is a nightmare right off the front end when you get hit with one of these summons and complaints, and it is expensive. Attorneys are expensive. The forensic experts are expensive. Once discovery takes place on top of just the initial imaging, usually there's a protocol that we negotiate. If we can't negotiate it, the court's going to order it. Nobody really wants that usually. And the protocol typically has, some agreed upon custodians. You may have to go fight with the court about who they are, but, and what devices are going to be searched. You have search terms that are run, and then you look through, basically then if I'm the defendant attorney, I'm going to look through the search results. The search results are huge. I mean, phones, a lot of times, I'm going to be looking at 36,000. A lot of times the way they get processed, they'll kind of be in a spreadsheet, an Excel spreadsheet, 36,000, 45,000 lines of text messages, things like that. It takes a long time to go through, and you have to do it to make sure there's not like personal sensitive stuff that the other side's getting, or returning client stuff. It takes forever, and it is a tremendous expense. Not to mention, it's probably, I've never been on the other side where it's my phone getting imaged, but I'm sure it's not pleasant. Even though I'm weeding out personal stuff, I'm sure that the people whose personal stuff I'm looking at, because I see it, I'm sure they don't love it. And a lot of times I feel like I probably know more about them than a lot of people close to them know about them after I look through all that stuff. Not that it ever is mentioned or comes out, but it's not pleasant. And then also, I mean, you've got these key employees who are worrying about, who are in there having to get their phones to go get imaged for a while. I mean, just in having to deal with the discovery process on their end, they're taking time that they should be doing business, worrying about this stuff. All right, so this slide is about, this kind of gives you an overview of how things get started and kicked off in these cases. So, former employee leaves, or an employee leaves, and the former employers, kind of thinking, okay, I'm worried about what they might have done. There's a few things they can do on the front end. They can, most of the time, one of the first steps is going to be to image their computer that was assigned to the former employee. From that, you can see like USB registry, which is, you can see everything that has been plugged into the computer, and when it was plugged in. You can see all the internet sites they've been to. You can see all their local file access histories. So anything that's stored locally on their drive, you can tell a lot about what they're accessing. You can see some history. It's not quite as good, but you can see at least some of it and depending on the network and all that, there's other ways you could get the same thing. But what are they accessing on the network through their computer locally? And then, depending on the environment that the employer has set up, there's all kinds of other things that may be available. They may be able to like figure out all exactly when the employee accessed anything on the network. A lot of times they can figure that out. I had one client one time that if there was like some sketchy keystrokes or activity, the computer would just start recording exactly what the employee did. I thought it was really cool. So you just watch a video, and the employee didn't know what's happening, but you could like watch a little video and watch them open that file and click on it and move it, and you could see them moving it over to a thumb drive. It's pretty cool. Sometimes video surveillance can be important. Email activity is one. A lot of times employees will email themselves stuff, and to their personal email, and they may try to delete it, and they may think it's deleted, but it may be still there. And the employer can usually find that. And I've had two cases involving whistleblowers who the hiring employer had like a whistleblower come forward. I mean, you can kind of imagine there's like politics in these employers, right? So you get some new employee who thinks they know everything, and then one of the older employees gets kind of ticked and is like, doesn't like the person, and so they'll write an email or call the former employer and be like, hey, there's this guy here who says he's got some of your stuff. You may want to look into it. That happens. All right. So here's some examples on kind of what we just discussed. So these are cases I've been involved in. There's a lot of others too. These are just kind of a short list of examples. But yeah, I mean, if you insert a USB device, you can't always see what was copied onto that device, but you can look at the file activity and kind of infer through circumstantial evidence what activity was. And if they don't have that USB device, they're like, what is it and where is it? You write a letter like, if you don't let us take a look at it, we're going to sue you. Or maybe you just file a suit. Another case I had, this was sort of a sophisticated employer, not sort of, they were sophisticated, they were big and sophisticated employer. They had some method, I don't really understand it, but they could see how much data was uploaded from an employee's station to the internet at a particular time. And then you could go into that employee's computer, internet history, and we saw he's visiting Google Drive. So clearly he's uploading stuff onto his Google Drive. And then based on that, in that case, what happened was they had some investigator that kind of called the guy and asked him questions and wound up catching the guy in a lie. And we filed suit, and we'll see in a minute. I'll show you what we discovered after that. Like I mentioned, I had a case where they could record what was going on. It was really cool. And then I've had cases where we saw that the guy was forwarding work emails and documents to his personal email, and then he'd try to delete cover it up, but he didn't. And then I've had two or three, really three cases that involved a whistleblower, believe it or not. Um, so, and here's what the former employer, once they kind of have that first step in the door, here's what they can get and discover. And this is kind of where the terribleness comes in. And I'll tell you, the scope of what the plaintiff can get is kind of sliding scale with the evidence that they have to begin with. So the more evidence they have on the front end, sort of the more they can get. And then sometimes what happens is you may only have a little bit, but you get more in discovery. And then after that gets revealed, you get way more in discovery. But I mean, look at that third bullet point here. All thumb drives, phones, computers. I mean, it is like, it's unbelievable how much information you can get potentially in discovery. Text messages, WhatsApp messages, photos, Facebook messages, work email, personal email, Teams items. So in Teams, I don't know. At least I don't know if they do that for all Teams meetings, but in cases I've had clients who had that they have all these recordings of team meetings, and there's AI that's transcribing it. So when we run our search terms, when they use those words, it comes up, and you get the whole video. And that's interesting because most of the time we're really dealing with written documents, and I get so frustrated with employees who say the stupidest things in emails and text messages. They think that it's not discoverable. I don't know why. I mean, even after I tell them that it's not, everything you put in writing is potentially discoverable, they'll send text messages after that. I don't understand it. I don't know what the mentality is, but that happens. I can sort of understand on a Teams meeting, well, you're just talking. You might not think that's going to be written, but it is. Sometimes it's recorded, transcribed. It can be discoverable. I mean, there's nothing, unless it's privileged, there is nothing that's not potentially discoverable. Keep that in mind. And nobody picks up the phone anymore. I mean, nobody picks up the phone. That the fact that people text and put WhatsApp messages has turned what before all of that would have been a nothing case into a multi-million-dollar nightmare because people don't pick up the phone. They just text and message. And that'll get you in trouble. So here's some examples. The 1,500 files of the former employer, that was the guy that uploaded stuff to Google Drive, the 15 gigabytes. We got in discovery. We found out that stuff he was uploading was like 1,500 files of the employer's stuff. Uh, you know, actually, I'll mention this in a minute. The external drive of files from the old employer, we there was a ton of stuff, and that was the one that the whistleblower, he said, "Hey, this guy says he's got stuff." We filed suit, and we found out. I mean, the guy lied to us and said he didn't have anything, but we ultimately in discovery found out that he did. And then text messages I've had cases where text messaging a recruit while they're recruiting them, and then they ultimately hire them, but they're requesting files from his employer. And like in that case, I think the person was like, well, I don't want my employer to see me get the file from that computer. So let me go find something old that I have that may have an older version of it. And I'm like, yeah, why are you putting all this in writing? I mean, if you're gonna cheat, I mean, clearly it's wrong to do it. So not only are you doing it despite that, you're recording it for you're making sure that we have a record to show that you're doing it. That happens all the time. That's not a one-off. That is a very typical thing I see. I had one where there were some phone app messages, and they were talking about a document they had gotten from an employee they hired, and they were talking about how they could keep it in the place where it would be hidden and it wouldn't be admissible in court. I don't know why they thought that wasn't discoverable, but it was. It was on the person's phone once it got imaged, and that's not a good. I can't not produce that email. It's responsive, not a good document. Um, I had one where there was an email exchange where one employee said, "Hey," they were both had come over from the old employer. They said, "Hey, do you have the X file from our old employer?" And the guy responded, "No, period." And then he went on to say, "No, I got rid of it while or because the lawsuit was filed. I used to have," or something. I was like, you could have just said no. I mean, if you're going to not pick up the phone, you could have just said, "No, I don't have it." But he went on to talk about how he deleted it after the litigation was filed. So now you've shown that you had something you shouldn't have had, and you have showed that you spoliated evidence by deleting the evidence of it. So, it's unbelievable what people, and that was after the lawsuit. I didn't represent him, but he had a good attorney representing him who I know told him everything's discoverable. And he sent an email like that anyway. And I'm telling you, employees are idiots. And I'm not talking about low level. These are high. These people make way more money than I do, but they do this kind of stuff anyway. It's unbelievable. A couple of notes about the first two bullet points here. So it's a pretty good little case study. I was actually representing the plaintiff in both of these cases. In the first one, the offer letter that the hiring employer sent the employee said to him very clearly, "You're not going to take any documents with you. We don't want them." So that was a good sign. We decided not to sue the hiring employer because we didn't feel like we had information that it had done anything wrong at that point. And we wrote them a cease and desist letter though regarding our concerns. And unbeknownst to us, because this all happened pretty quickly, after they received our letter, they did their own investigation to figure out whether he took anything, and they discovered that he did on the computer they had issued to him. He had not only uploaded those 1,500 files to Google Drive, he downloaded them onto his computer despite lying to them about it. So they terminated that guy immediately. I mean, it was upsetting to them because they probably invested a good bit in getting him and recruiting him and all that. But they terminated him, and we never did sue that employer because they were so proactive, and it was clear to us that that employee was acting on his own. In another case, and it's actually the same client, this was the whistleblower case. We wrote the new employer, and they claimed to do some little investigation. So we didn't sue it first because we didn't quite have enough information that they had done anything. And then we get documents back from the employee that showed that he had a whole bunch of stuff, hard drive full of stuff. And, despite what his new employer kept telling us. So we sued that hiring employer in that case. And I'm sure that they wish they had taken that investigation a little bit more seriously on the front end and avoided a lot on the other end. So that's two pretty good case studies about hiring employers who had two very different outcomes based on how they handled a situation. So just to recap, I mean, a little bit of a logic proof for sort of what we discussed here. There is a decent chance, as we saw from that BISCOM study, that absent intervention, an employee hired from a competitor is going to take documents from that competitor. Now, it may be documents that employee created. Those are still the competitor's documents. All right. And if that occurs, we've seen that the competitor, and if the competitor is paying attention and cares, there's a good chance that that competitor can find some evidence that the employee took its documents. There's just so many avenues for that with the way systems work. And, depending on that employer's systems, they're going to have more available than others potentially. But there's a few ways employees can be pretty good about, getting stuff without letting anybody know. I don't even want to mention what they are, but, for the most part, like there's a good chance there's going to be some evidence that shows what they did. Once you get some evidence, you kind of get your foot in the door. This is a third bullet point. Once you have something and your foot is in the door, the former employer can potentially get a whole lot of other stuff. That's what we saw with all the thumb drives, phone imaging, all of the emails of the employer, all the documents on the network, all the Teams chats, all the Teams meetings. That's potentially all in play once they have that first bit to show something was taken. Now, again, I'm not saying they get every single phone of every employee. It's going to be, case specific, but, depending on how bad the evidence is on the front end, there can be a whole lot that they get. And if the fourth bullet point is, if the hiring employer makes some sort of incriminating statement in writing, or like even verbally at a recorded meeting, it can be discovered. So it's not just, oh, there's 1,500 documents that you took and we can see what the documents are now. It's even if you didn't take documents, if there's an incriminating statement talking about, having taken documents or having used some critical information, that's extremely damaging and discoverable, even if it's on your phone. And then we saw from the Stout study that, cases where documents are taken, and really they just did misappropriation of trade secrets. So that may include cases where documents were not taken. But I mean, I know from my experience, and certainly the higher end cases that we saw in that study, probably documents were taken. Those carry tremendous exposure, especially when they're coupled with incriminating statements. So being mindful on the front end is extremely important and can save a lot of money. So, I mean, on that point, here are some steps that we can sort of look at that can mitigate, not necessarily avoid. I mean, there's some lawsuits you can't avoid, and there's things you can't control as an employer, but there's things that can mitigate or reduce the risk. And so, and the earlier the better. I mean, the one example I gave earlier, where the company was proactive, they did that after, I mean, they did have the step of at least instructing the employee not to take anything on the front end. But then on the back end, they also kind of launched their own investigation. That was earlier than, that was early, maybe not as early as it could have been, though. One thing to keep in mind, I mean, this is so obvious, but it happens all the time. Don't ask the recruit for any documents. In fact, you need to instruct them not to take any. Don't ask for any information. Same thing, not just documents, but also any kind of confidential or proprietary information. I really, if there's a restrictive covenant, I strongly recommend that you hire an attorney with experience in the area to discuss risks and help come up with a plan for what that employee can do during whatever restricted period it is. I mean, there are some attorneys, if they don't really know, they may say what lay people do. Well, they're not, nothing's enforceable, right? And also just kind of knowing how the litigation process runs if there is an issue, I think is pretty important for an attorney to help advise a client. Also help come up with a plan for like the resignation and the onboarding of the new employer. That's really the most, I mean, the restrictive covenants is extremely critical. That's extremely critical too, because it's going to involve, and I think it may be on the next slide, yeah, an interview of that employee to make sure that that employee doesn't bring documents. Y'all, sometimes some of it's inadvertent. I mean, sometimes, we use sometimes our personal stuff. Sometimes we email ourselves stuff for valid work reasons, earlier on. And employees don't, even that can be problematic. That can taint a case when that happens. So being proactive, including an interview of the employee about, don't just ask them, do you have anything? Because you're going to say no. Ask them, did you ever use your personal email to like do work at home? Did you use your work computer? Did you save things locally on your work computer? Did you use like Dropbox or Google Drive or any other kind of like transfer thing just to move things around to make it easier? Did you ever go out of the office and do presentations there where you had to use like a third party type thing? Did you ever print things and take them out? I mean, there's a whole litany. I've got an outline of questions I ask. If you ask them, did you take anything? No. Okay, let's talk about these things. And every time, oh yeah, I probably do have that on there. So you need to be proactive because it's not intentional always. I mean, you need to be proactive. Sometimes it is intentional. So I think that interview process also needs to come from somebody who's seen what a disaster it is if they take documents to try to convince them that you don't want to do this. I mean, and explain to them what the potential repercussions are of having documents after you leave. That will get their attention and help them not do whatever it is that they want to do. Because I mean, not just that BISCOM study, I've seen it, I've talked to these people, and they want stuff a lot of times, and the front end trying to convince them otherwise can save you a lot because the stuff is not that helpful. I promise it's not. The duty of loyalty, we haven't discussed a ton here. That's a fiduciary duty, but that's in play while the person's still employed with the former employer, and it can linger afterwards. But the employee can make huge mistakes before they leave if they start talking to customers. Hey, I'm about to leave, blah blah. I mean, that's a problem. If they start talking to other employees and like poisoning the well, like, hey, this place is a dumpster fire, I'm about to leave and they're never going to recover, why don't you come with me? That's a huge problem. And sometimes they have non-solicitation employee covenants that would be violated too. So having those conversations on what they can and can't do with respect to customers and co-employees during that period where they're looking to leave is critical. And we've only, I mean, we haven't touched on that a ton, but that is another huge part of what can get somebody in trouble, is doing pretty much anything bad during that time period can be a violation of the duty of loyalty. And then, notice is that this kind of goes to the duty of loyalty too. Notice is an issue. Like, so I had a case one time where the person resigned and didn't, I think under their contract, they were supposed to give 2 weeks notice, but they resigned and like left. And one of the allegations in the case was that they left everything a mess and nobody could figure out what was going on with their projects. And they allegedly had deleted stuff or something to make it difficult. And so they were having trouble servicing these customers. And so it was the argument was kind of, well, you set it up perfectly so that we wouldn't be able to service these customers. They'd have no choice but to go to you. And there was in that case he didn't mean to delete the stuff, so it's kind of BS. But that could be a pretty powerful argument. Poisoning the well before you leave to set things up for your new place is a big problem. On the other end, I've had employees that want to resign and they don't want to tell the employer where they're going. And I'm kind of like, well, the problem is you kind of need to like offset, you kind of want to offer to be available for help, just at least from an optics standpoint, right? And so if you don't tell them where you're going, I mean, sometimes they're going to ask, and if you don't tell them, they're going to know. But if you don't tell them, then and they keep you around for 2 weeks, that 2 weeks scares the heck out of me as a lawyer that might be litigating what you did, because you got a duty of loyalty during that entire time. And that's a long time for you to screw up and to know that you're really going to be going to a new employer down the road. And so I don't like the situation of them working that 2 weeks. I like offering to be available for help, but I don't like it when they're going to actually work 2 weeks, unless the employer wants them to, and the employer knows they're going to a competitor. That maybe is unavoidable, but I don't want a situation where the former employer doesn't know that. And then finally, spoliation issues is like, I think I touched on it briefly earlier. I don't have like a special slide for it, but that's like a huge issue lurking in all of this. It's with digital evidence, it's always being overwritten. Deleted items can be recoverable, but only for a certain time period, because your computer is always overwriting space. And so it's overwriting deleted files to some extent. And spoliation issues, like when there's a lack of evidence, or even when there is evidence, spoliation issues can be worse than the evidence in some ways, if it looks like something wasn't preserved properly. And so an attorney can help with that issue too, with making sure that like the right items are imaged, and the right emails are preserved and things like that, because that is another area where somebody can run into problems. So it looks like I managed to time this so that we have about 2 minutes left, but I think we're probably okay to end 2 minutes early. I probably have put you all to sleep because I don't see any chat messages or questions. But if you have any questions or you have any thoughts about anything, don't hesitate to contact me or let us know if you have any specific issues. Here's I forgot I have a couple of slides. This is really just kind of what I was already talking about. Offer letter, like that client did, or like that other party did, and having a client that puts instruction not to copy documents is also pretty important. So anyway, I appreciate everybody being here if you're still awake, and don't hesitate to call me if I can ever be of any help. Certainly, I recommend that if you hire somebody key, y'all call some attorney who has some experience in this area, because it can really save you a whole lot on the back end. Thank you.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.